We've all heard the horror stories, right? A homeowner getting into a battle with their HOA. But what happens when a homeowner doesn't just fight back, but takes their board to court on 6 different issues? Well, today we're going to dive deep into one man's quest for accountability and what it teaches all of us about the rules that govern millions of our homes. It's a question a lot of us have probably wondered about. I mean, HOAs have these big rule books, they've got lawyers, and they have the power to fine you. It can definitely feel like an unfair fight. But what happens when one homeowner decides to challenge, well, pretty much everything?
So, let me introduce you to John Krahn. He didn't just disagree with his HOA board, he took them to court. And he didn't do it just once. Nope. He filed 6 separate, single-issue legal challenges, forcing a major showdown on a whole bunch of different fronts.
All right, so let's set the stage. On one side, you've got Mr. Krahn, and on the other, you have the Tonto Forest Estates Homeowners Association. And the battlefield for this whole conflict? It's one single central document, the rulebook that governs their entire relationship.
That rulebook is called the CC&Rs. The easiest way to think about it is like a contract for the whole community. When you buy a home in an HOA, you're legally agreeing to follow all these rules. But here's the kicker, and this is key. The HOA board has to follow them too. And that is where our story really gets going.
Now, even though there were 6 different disputes, we're going to start with the main one because it really gets to the heart of what's fair. It all centers on the community's septic systems and a really simple question: who should have to foot the bill?
The situation was pretty straightforward. In this community, there were basically 2 kinds of lots. You had lots with houses on them, which had septic systems installed and obviously in use. And then you had these empty, undeveloped lots. No house, no septic system, nothing. The problem? The HOA was charging every single lot, whether it had a house or was just empty dirt, for septic system maintenance.
So, here's where it gets really interesting. Both the homeowner and the HOA were looking at the exact same rulebook, and they came to completely different conclusions. Both of them were totally convinced that the CC&Rs were on their side. Let's break down their arguments.
Mr. Krahn's argument was all about the specific wording. He pointed right to a section of the CC&Rs that says the HOA's responsibility for maintenance begins, quote, after installation, and, crucially, the costs are payable by, quote, such owner. So his point was simple. If there's no installation, there's no obligation to pay. And that phrase, such owner, clearly refers to the owner of the lot with the system, not every single owner in the neighborhood.
The HOA, though, they felt totally trapped. They were pointing to a different part of the rules and, more importantly, to a previous court case. That older ruling said assessments shall be allocated equally among all lots. So they believed if they didn't charge the empty lots, they'd be breaking that rule and could get sued by other homeowners. You can see why they felt like they were in a no-win situation. So you have these 2 competing ideas from the same rulebook. One is super specific about septic systems. The other is a general rule about equal payments. It was all going to come down to how a judge would read the contract.
So, who was right? Did the specific rule about septic systems win out over the more general rule about equal assessments?
In the end, it really just came down to plain English. The judge sided completely with the homeowner and even called the CC&Rs clear. That phrase, after installation, meant exactly what it sounds like. Only the lots with actual septic systems could be charged for maintaining them. The specific rule beat the general one. Case closed.
Now, that was a huge victory for the homeowner. But remember, that was only one of 6 cases. So let's look at the other 5, because this is where a really fascinating pattern starts to emerge.
Let's just run through these real quick. Improper payment? The HOA paid a board member back for a septic part, but the rules said that was the owner's job. Judge agreed. A violation for a tree? The notice didn't even say which rule was broken. The judge sided with the homeowner. Secret ballots being stored improperly? Yep, that compromised anonymity. Another win. A records request? The HOA wrongly held back documents? Another win. The only case the HOA won was when they filed an insurance claim in a closed meeting, which the judge said was okay because it was related to a lawsuit. So when you add it all up, the final score is just stunning. The homeowner, Mr. Krahn, won 5 out of his 6 legal battles against the HOA. This was not a fluke. It was a clear pattern of a board that just wasn't following its own rulebook. You know, this case is so much more than just some local dispute. It's basically a masterclass for anyone living in an HOA.
So what are the big takeaways? Why does any of this matter to you?
First things first, read your documents. The judge called the language clear, and that clarity was Mr. Krahn's most powerful weapon. Second, the little details matter a lot. That whole septic case came down to tiny words like after and such. Third, procedure is everything. The HOA lost a bunch of these cases not because of what they did, but because of how they did it. Improper notices, messing up ballot storage, stuff like that. And finally, this whole thing proves that you can hold your board accountable. The system might look intimidating, but it is there for a reason.
Which really brings us to our final question, and this one's for you. It's so easy to just ignore that thick binder of rules you got when you moved in, but as this case shows, knowing what's inside isn't just about avoiding a fine. It's about understanding your rights and making sure the rules are being applied fairly to you and to everyone else.